Welcome to Cardamone Law University, translating the Pennsylvania Workers' Compensation Act into plain English for injured workers. It's Mike Cardamone here. Today I wanted to talk about attorney's fees in a Pennsylvania workers' comp case in terms of the injured worker and their attorney, that relationship. Not speaking about how the attorneys for the employer and insurance carriers get paid, but just in terms of injured workers. The bottom line here is that there's no payment that you have to make out of pocket to hire our firm. It's a contingent fee system. What does contingent fee system mean? That means that we only get paid if we win, essentially, or if we settle your case. And any fee for an attorney has to be approved by a judge in what's called a court order. If there's no court order, we can't get paid. And you only get a court order if there's successful litigation or a settlement. So let's go over the three main ways that we would get paid and how much we would get paid. Basically, it's a 20% fee in Pennsylvania, 20% of the wage loss benefits. There is a case that came out a couple years ago that permitted claimants' attorneys to seek a fee on medical treatment as well, medical bills. We don't do that. I don't think most firms do that. I personally don't find it fair, and it puts our clients in a tough situation. So we're really just talking about the wage loss component of your benefits. The first way is if you get a denial in your case, workers' comp denies your claim, and you get a notice of denial. We file a claim petition. We litigate the case and we win. Or if we get them to agree to what's called a stipulation where they pick up the claim and start paying the benefits, we would get 20% of the wage loss benefits. In another situation, if you're already on workers' comp and the insurance company tries to attack your benefits, and there's three main ways they can do that: petition to terminate, alleging a full recovery, a petition to suspend benefits, which says that you have your pre-injury earning power back but does not affect the medical benefits, or a petition to modify benefits, which states that you have an earning power that's under or less than your pre-injury average weekly wage. If the insurance carrier files one of those petitions and we win, and most of the time there's a thing called supersedious, where the judge makes an initial ruling as they sort of peek at the evidence, and we normally win that, and we would start getting paid 20% of the checks. And unfortunately, injured workers don't really have a choice. If they go about this on their own, they tend to get railroaded. So the judges at the hearings will tell the injured workers and remind them that they have a right to seek an attorney. And some are more forceful about it than others, but it's just the way it is. It's like, okay, you can have your benefits shut down or reduced, or you can take a 20% cut. And so most people elect to take the 20% cut. And then we can also set up the case for settlement, and injured workers who have attorneys tend to double or triple their money. So it's a no-brainer. But in any event, they're the first two ways that you can see a contingent fee. Again, either we win a claim petition, or get the insurance company to enter into a stipulation for an agreement to pay benefits. Or conversely, if you're already on workers' comp and we defeat their petition to try to reduce your wage loss benefits. The third essential way to get paid in a workers' comp case in Pennsylvania is a settlement. So if we reach what's called a compromise and release agreement, where the case is settled for a lump sum, then we'll receive our 20% fee. So there's no out-of-pocket payments, and although most fee agreements will state that if an injured worker fires their law firm, that they'll be held responsible for, litigation cost and perhaps a quantum meruit fee, meaning it's a Latin phrase that means as much as he deserves. In other words, if a firm puts in a lot of hours of work and then the injured worker fires them, hires a new firm, and they settle it, the prior firm is going to have a claim, most likely, for some of that fee. Now, the injured worker is not going to pay an additional fee. It's just that the attorneys are going to be haggling over how to split that 20% fee. And with respect to the litigation cost, I've never had a client in 23 years pay us that. What happens is, let's say a client fires our firm. Doesn't happen frequently, but every now and then that happens. We'll send the litigation cost to the new attorney, and they'll protect it. And if they settle or win the case, they'll get paid, and then they'll reimburse us. So I've never gone after an injured worker ever for payment. They've never sent a check to me, and that's the way it's going to remain. So you have to remember, so many injured workers will not seek representation and get railroaded because they think they can't afford it. You can't afford not to get representation. You cannot afford not to get representation. And I'm really serious about that because there's so many injured workers that have bad information, or they don't like attorneys because they heard a story in the news, or they think there's going to be a big target on their back at work, things like this, and they don't get the help. And this is your earning power on the line. What's more important than that other than your health? Nothing. So it's really important to get advice so that you're getting the maximum pay for your case and the maximum settlement. And I can't stress it enough. You do not have to send us a check, cash, credit card, nothing. Again, it's a contingent fee system. And I wanted to make that really, really clear because there's so much bad information out there. And it's really one of the first questions people will ask is, how am I going to pay you? And I say, it'll be out of the wage loss checks or the settlement. Do not have to send us any money. And it's really nice because that levels the playing field. You know, the insurance companies have unlimited money, and injured workers need to make sure they get counsel on their end so they can fight back. If you have any questions on this, make sure to call us, all right? 215-206-9068. You can email me directly. It's Michael, so Michael, at cardamonelaw.com. So it's Michael at CARDAMONELAW.com. And we'll be happy to answer your questions, whether it's about the fee agreements or any other aspect of the Pennsylvania workers' compensation law. We'll be more than happy to help you out. That's all for now from the Cardamone Law University. We'll talk to you soon. Bye-bye.